John, who is a former employee who recently left the firm. He has been introducing himself as a partner of tech solutions to various potential clients. John retains a business card with the title partner that was mistakenly issued to him during his tenure. Although John no longer works for the firm, Sarah and Daniel are aware of his continued misrepresentation but have not taken steps to inform the public or potential clients that John is no longer associated with the firm.
So for the case one for the scenario is John has retired from becoming a partner but still act as he is. And the issue that has been identified is whether Sarah, Emma and Daniel are liable to joint action or not. And the legal issue that may arise from this case is liability of a person for holding out. So the liability of a person for holding out, according to Section 16 of Partnership Act of Doctrine based on estoppel, is that if a person knowingly allow himself to be represented as a partner for a particular firm, and so to induce the third party to act upon the representation, that person will be liable for the debt, but only for the third party. However, the creditor can sue that person for the debt of the firm, whether he or she is not or no longer a partner for a firm. And this can be seen in the case of Tower Cabinet Co Ltd versus Ingram. It was held that Ingram was not liable for the debt as he not knowingly suffered himself to be represented as a partner.
So, in this case, John is no longer a partner to Dissolution, but he still represented himself as a partner to the potential customer. Sarah and Daniel had known about John's misrepresentation, but they had not taken any action about it. Then, John will be liable for any debt incurred by the large company because he knowingly represented himself as a partner and made the large company enter the contract with his assurance. Sarah, Daniel and Emma will also be liable since they had not taken any action to notice the customer about John's status, which gave John an apparent authority to his action. The conclusion in this case is John will be liable for the debt of the third party, and Sarah, Daniel and Emma will be liable for their negligence. The other probable outcome that we can get from this case is if Sarah, Daniel and Emma had not knowingly about John's misrepresentation, they will not be liable for any liability incurred by the large company that entered the contract with John's assurance.
A few moments later.
Daniel discovered that Emma had been providing private consulting services to several clients using the firm's resources, including office space and proprietary materials. Emma did not inform Sarah and Daniel about this private engagement, nor did not share the profit made from these services.
The issue has been identified whether Emma has breached her duty to the firm by providing private consulting services to several clients using the firm resources, including office space and proprietary materials. The legal issue that may arise in this case is duty to account for any benefit derived from any transaction concerning the partnership. According to Section 31, duty to account for any benefit derived from any transaction concerning the partnership provides that every partner must account to the firm for any profit derived by him without the consent of the other partners from any transaction concerning or from any use by him of the partnership property, name or business connection. The partners cannot keep the profit for himself but must account to the firm and therefore entitled to be shared by all the partners. If he fails to do so, the other partners can sue him to claim a share in the profit as he had breached imposed by the section. This can be referred to in the case of Patirana versus Arya Patirana regarding the duty to account for any benefit derived from any transaction concerning the partnership. It was entitled that the other partner has a share in the profit. From the case given, Emma, who is a partner in tax solution, had been providing private consulting without the knowledge or consent of other partners. She has been using the firm's resources such as office space and proprietary materials while conducting private consulting. Emma's action has raised a legal issue regarding the breach of duty to account for any benefit derived from any transaction concerning the partnership. From Emma's situation, Sarah and Daniel were entitled to have a share in the profit. This was because the profit were derived from the use of partnership premises and materials without the partner's consent. Emma cannot keep the profit for herself and must account for the firm, therefore to be shared by all the partners. If she failed to do so, the partners can sue her due to a claim a profit as she breached her duty to account for any benefit derived from any transaction concerning the partnership.
So, the possibility outcome for the given situation is to avoid legal actions against Emma. Emma should inform about the private consulting to Sarah and Daniel. Sarah and Daniel might support Emma actions and can leading to a mutual beneficiary agreement where she can continue to contribute her skill to the firm. Emma also can should negotiate the profit to share among the partners for using the firm resources if she ever want to continue her private consultation service. And this can encourage Sarah and Dina to seek early solutions outside the court.
Sarah has recently been diagnosed with a debilitating illness that significantly impairs her ability to continue providing consultation service. Given her condition, Daniel and Emma are considering applying for a court order to dissolve the partnership as Sarah is no longer capable of fulfilling her role.
The identification in this case is one of the partners is having permanently ill that cannot be recovered, or the partner can be recovered but it will take time. The ill will affect to the partnership because the partner cannot do her own job in the partnership. The legal issue that we can use in this case is dissolution by order of the court. In this dissolution, if a partnership cannot be dissolved by anyone in the partnership, they can apply to the court to get an order of dissolution.
Dissolution by order of the court cannot dissolve by anyone, but there is another alternative to dissolve the partnership, is making an application to the court to get a dissolution. Dissolution by order of the court can using because of the Sarah cases, which is the partner have a permanent incapacity to perform her duties. Under Section 37B provides that on application by a partner, the court may decree dissolution of the partnership when a partner other than the partner is suing become in any other way permanently incapable of performing his part of the partnership contract. Based on these legal issues, meaning that if the partner cannot contribute into a partnership because of the incurable illness, will be one of the reasons to partnership to apply for this dissolution. Before they are become a partnership, there is agreement between the partners. If one partner cannot capable to fulfill the role, they will turn into dissolution. The referred cases by permanent incapacity of any partner to perform his duties is Whitwell versus Arder 35 340. One of the partner was filed for dissolution of the firm because of the incapacity to perform his duties. One of the partner sued for dissolution because found that the partners having a paralytic attack. Now I will explain for the Sarah cases. which is Sarah, was diagnosed with a debilitating illness that she incapable to perform her duties. Her duties, which is being a consultation services. As the consultation services, she has a lot of the job to do and get the client for the partnership. From her illness, she may not meet all of her clients because she will have a lot of therapies for her illness. Moreover, it will be effect for her partnership due to she need to take time to recover from her illness and she may not recover from her permanent illness. Next, the outcome from this situation is Sarah has been diagnosed with the debilitating illness that will impair her ability as a consultation services. The consultation services is important because that job need to face a lot of clients for the firm. She may not recover from her illness, so the partners can apply to dissolve the partnership by order of the court because of one of the partners are incapable to perform for her own duties. If they are not choosing to dissolve a partnership, that may be effect for their firm because of they already having their own rules in the partnership, but one roles are empty and they are cannot replace to another partners to fulfill their own rules. Moreover, Daniel and Emma only can suit for the dissolution and not by the partner who suffers from the incapacity, which is Sarah. In addition, Daniel and Emma can get the evidence of the Sarah disease to use in the court like medical records from the doctor to make sure that her illness are true and her incapacity to perform a partnership. Lastly, the other probable outcomes for Sarah cases. Based on the Whitwell versus Arthur cases, the defendant has medical evidence that his illness are not permanently and be recovered. The order by court decide that they are not accept for the dissolution because of one of the partners can recover and come back to perform his own roles in the partnership.
We can relate it to Sarah's situation too. If she has a chance to recover from her debilitating illness, the dissolutions by the order of the court can be void and will not be accepted. It is because of Sarah has the capability to continue her job as consultation services, and the firm can continue their business smoothly.